It started as a routine federal hearing in Washington, D.C., the kind that rarely draws national attention. But this time, the air in the courtroom was thick with anticipation. On the docket, a civil suit tied to a controversial executive directive issued during Donald Trump's presidency, drafted in large part by his former advisor, Stephen Miller. Presiding over the matter was U.S. District Judge Eleanor Mercer, a sharp, no-nonsense jurist with a reputation for her fierce independence and legal precision. Cameras weren't allowed in the room, but journalists packed every available seat, sensing that this wasn't going to be just another hearing. Within minutes of the opening statements, it was clear Judge Mercer had no intention of treating the case lightly. She interrupted the Department of Justice attorney mid-sentence. "Are you seriously asking this court to pretend this directive was grounded in constitutional authority?" she said, her voice rising slightly, when the internal memos show clear intent to bypass judicial oversight and target entire communities. A rustle of murmurs spread across the courtroom. At the heart of the case, a leaked draft memorandum allegedly signed by Stephen Miller in early 2020, pushing for mass detention centers and revoking protections for certain asylum seekers, moves that civil rights lawyers argued were not only unlawful but potentially criminal in their scope and execution. But the real shock came when Judge Mercer directed her next comments not just at the legal counsel but by name. "Mr. Trump and Mr. Miller may not be present today," she said, "but let the record reflect that this court finds their conduct, as alleged, troubling to a degree this bench rarely sees. If proven, we are not merely talking about policy failure, we are talking about potential violations of federal law." Reporters scrambled to tweet. Stephen Miller, watching remotely from a law office across town, looked visibly shaken according to staff who later spoke anonymously. And Trump? He hadn't yet reacted publicly, but his legal team was already on high alert. This was no longer just about a directive. It was about the possibility of real legal consequences for two of the most polarizing political figures in recent memory. The courtroom emptied slowly after Judge Mercer's fiery remarks, but the impact outside was immediate and explosive. Within hours, every major news network was running variations of the same headline: "Federal Judge Targets Trump and Miller Over Alleged Abuse of Power." Mercer hints at legal consequences, not just policy failure. Legal experts flooded panels, dissecting her statement line by line. Former prosecutors noted how rare it was for a sitting judge to directly name political figures not present in court. But Judge Mercer wasn't bluffing. Her words signaled a seismic shift, from judicial review to potential criminal exposure. Meanwhile, Trump's legal team scrambled behind the scenes. His lead counsel, Robert Kilner, called an emergency strategy session at Mar-a-Lago. "She crossed a line," Trump reportedly told his inner circle. "She wants to make this political." But what he didn't realize was that Mercer wasn't alone. Quietly, sources at the Department of Justice confirmed that a separate task force, initially formed to review irregularities in asylum enforcement, had already opened an inquiry into the drafting and implementation of the 2020 directive. Stephen Miller, known for his defiance, didn't remain silent for long. He appeared on a late-night conservative podcast and tried to dismiss the court's proceedings as a witch hunt by the radical judicial elite. "This is nothing but theater," he said. "They can't criminalize national security." But behind closed doors, Miller's tone was different. His former assistant leaked emails showing that Miller was now contacting private defense attorneys, asking about immunity options, just in case. Back in D.C., Judge Mercer issued a follow-up order. She was requesting an unredacted version of the 2020 directive's internal communications. If granted, that order could expose emails, draft memos, and back-channel messages between Miller, Trump, and key Homeland Security officials. The judge made one final statement before adjourning: "This court has a duty not only to interpret the law but to uphold it, regardless of the political cost." And with that, the legal trap quietly began to tighten. 3 days after Judge Mercer's unredacted document request, the Department of Homeland Security reluctantly complied. Over 4,000 pages of internal correspondence were delivered under court seal. But by the next morning, select excerpts were already circulating, thanks to a leak from someone close to the oversight panel. What reporters uncovered wasn't just controversial. It was incendiary. In one email dated February 12, 2020, Stephen Miller wrote directly to a high-level DHS official, "We need to fast-track detention models. I don't care what legal language you wrap it in, just make sure it's enforceable before the courts catch up. Trump wants numbers, not warnings." In another thread, a senior policy aide attached a revised asylum policy memo and included a chilling note, rewritten per Miller's guidance. Removed references to legal review. Language now more authoritarian, as requested. Judge Mercer reviewed the material in private chambers for over 6 hours. The next morning, she issued an official order unsealing 20 key pages of those communications to be presented in open court. When court resumed, Mercer's tone was grave. "These communications reflect a pattern of intent to circumvent the judiciary, mislead regulatory bodies, and enact orders with full knowledge they may violate federal protections. The court is deeply alarmed." Gasps filled the room as the most damning emails were read aloud. Trump's attorneys immediately filed an emergency motion to suppress the evidence, calling the leak politically motivated. But Mercer wasn't having it. "The law does not yield to fear, and this bench does not yield to power," she said, slamming her gavel with a sharp crack that echoed across the marble walls. Meanwhile, a quiet movement was brewing inside the DOJ. Several mid-level prosecutors, encouraged by Judge Mercer's transparency, formally petitioned the Attorney General to consider referring the matter to the Office of Special Counsel. Stephen Miller's legal defense team grew tense. They knew what that meant: potential criminal indictments under Title 18, covering conspiracy to deprive civil rights and obstruction of justice. For the first time, Miller reportedly canceled all media appearances. And Trump? He broke his silence with a single, furious Truth Social post: "Total judicial overreach. Fake emails. I did nothing wrong, and neither did Stephen." But few were convinced. Even among his loyal base, murmurs of uncertainty began to stir. The bombshell had landed. Now came the fallout. As the leaked emails dominated headlines, cracks began to form within Trump's once impenetrable legal fortress. Inside Trump Tower, a war room was reassembled, just like during the Mueller investigation. Except this time, the stakes felt different. Judge Mercer wasn't launching a political inquisition. She was building a judicial case, brick by brick, on sworn evidence and documented communications. Trump's lead attorney, Robert Kilner, slammed his fist on the conference table. "We're not dealing with cable news anymore. This judge is methodical, and if this goes criminal, we're out of civil territory. We're in orange jumpsuit country." Stephen Miller, appearing via secure video call, was pale and visibly shaken. One of his former DHS allies had just been subpoenaed to testify, and rumor had it he was considering cooperation in exchange for immunity. Meanwhile, Judge Mercer escalated the situation further. On the fourth day of hearings, she issued a judicial referral memo, a rare and powerful action, urging the Justice Department to launch a formal criminal investigation into the directive's creation and dissemination. Her words were searing: "This court is not rendering criminal judgment. That responsibility lies with prosecutors. But the court is compelled to refer when federal laws appear to have been knowingly violated by individuals operating at the highest level of government." By nightfall, the Attorney General's office had confirmed receipt of the referral. The possibility of a special counsel loomed large. Panic rippled through Trump's inner circle. One former White House counsel reportedly told associates, "The worst part isn't the judge's words, it's the evidence. Emails, edits, names. This isn't a political hit. It's a paper trail." Meanwhile, a congressional subcommittee, already investigating misuses of executive authority during Trump's final year, requested full access to the unsealed documents. The walls were closing in from every side: judicial, federal, legislative. Back in the courtroom, Judge Mercer made one final move that stunned everyone. She scheduled a closed-door evidentiary hearing for the following week and requested that both Stephen Miller and Donald Trump attend in person or be subpoenaed. That single order lit up headlines across the nation: Judge demands Trump. Miller faced the courtroom, under oath. The world was watching. And both men now had a decision to make: show up, and risk perjury. Or don't, and risk contempt. Security around the federal courthouse in D.C. was tighter than ever. Metal barricades lined the sidewalks. Protesters, supporters, and journalists swarmed the streets. The closed-door evidentiary hearing ordered by Judge Eleanor Mercer had turned the building into the eye of a national storm. Just after 9 a.m., black SUVs pulled up to the side entrance. Stephen Miller stepped out first, flanked by his legal team, his face stiff and unreadable. He ignored the shouted questions and camera flashes. Then came the moment no one expected. Donald J. Trump exited the vehicle himself, not from Mar-a-Lago, not via live stream, but in person. Wearing a navy suit and red tie, he moved briskly into the building, jaw clenched. It was the first time he had stepped foot in that courtroom since leaving office. Inside, the atmosphere was electric. The hearing was officially sealed, but leaks flowed anyway. A reporter from The Hill later revealed that Judge Mercer addressed both men directly, her voice unwavering: "You are not defendants in this court. Not yet. But this hearing is to determine whether your actions rise beyond reckless policy, into the realm of criminal liability." Miller was the first to be questioned under oath. For nearly an hour, he faced detailed questions about email chains, policy memos, and his role in revising asylum protocols. His answers were calm but evasive, until Judge Mercer intervened. "Mr. Miller, you were warned by multiple attorneys that this directive risked violating federal law. Why did you proceed anyway?" He paused. "For too long. Because," he finally said, "the president wanted it done." Gasps rippled through the room. Next came Trump. Though his lawyers attempted to answer on his behalf, Mercer insisted he respond directly. "Mr. Trump, were you aware that the directive in question bypassed legal review procedures?" "I was told it was fine," Trump replied. "Everything went through the White House counsel." "That's not the question," Mercer pressed. "Were you aware?" Trump hesitated, then deflected: "I trusted my people. That's all I'm saying." By the end of the hearing, both men had answered enough to raise serious legal questions, but not enough to clear themselves. Judge Mercer concluded with a final statement: "This court finds that there is sufficient cause to support continued federal investigation into the conduct of Mr. Miller and Mr. Trump in connection to the 2020 directive." A copy of today's transcript will be forwarded to the Department of Justice and the Office of Special Counsel. The hearing ended. But the real battle had just begun. Outside, cameras rolled as the two men left separately. Neither spoke. But inside DOJ headquarters, a new file was opened that afternoon. Case title: U.S. vs. Unknown, Federal Conspiracy and Civil Rights Violations, 2020 Directive Review. The Department of Justice wasted no time. Within 48 hours of receiving Judge Mercer's transcript and recommendation, Attorney General Helena Vargas, under mounting public and political pressure, announced a bold decision live on national television. After careful review of the sealed court hearing and internal DHS communications, she said, "The DOJ is formally appointing a special counsel to investigate potential criminal violations surrounding the drafting and implementation of the 2020 Asylum Directive. No individual, regardless of position, is above the law." The newly appointed special counsel, Nathan Hale, was a former federal prosecutor known for his relentless approach to political corruption cases. Quiet, unshakable, and with a history of successful convictions, Hale quickly assembled a hand-picked team of investigators. Subpoenas went out immediately, not only to Stephen Miller and Donald Trump but also to former DHS officials, White House legal advisors, communications aides who worked on messaging for the directive, members of the Office of Legal Counsel who had raised red flags internally. The investigation was no longer limited to civil matters. The potential charges under review included conspiracy to deprive rights under color of law, obstruction of justice, knowingly issuing unlawful executive orders, destruction or suppression of internal legal warnings. As these developments exploded across the media, Trump attempted to spin the narrative with a primetime interview. "This is a disgrace. I tried to protect the country. And now a partisan judge and the deep state want to criminalize patriotism." But behind the scenes, his legal team was unraveling. 2 key attorneys resigned abruptly after learning they had also been subpoenaed as witnesses. Meanwhile, Stephen Miller was reported to be considering a plea deal. Sources close to his defense team said the weight of the email evidence, and the likelihood of his former staff turning on him, was devastating. In private, Miller allegedly told his lawyer, "They'll throw me under the bus to protect him. I can see it already." Judge Mercer, meanwhile, remained silent, bound by her judicial oath and unwilling to comment publicly. But her ruling had changed everything. She had turned a slow-burning lawsuit into a potential career-ending wildfire. Congress called an emergency bipartisan committee hearing. Senator Lydia Torres, a centrist Democrat from Arizona, put it plainly, "If the evidence proves a willful abuse of power at the highest level, then our democracy demands accountability, not delay, not spin, and certainly not immunity." The country braced for the next stage. Trump and Miller were no longer just names in a lawsuit. They were now names in a criminal case. As the special counsel's investigation gained speed, pressure mounted on those closest to Trump and Miller. One by one, their inner circle began to fold. The first major defection came from Carla Jennings, a former senior legal aide who helped coordinate the directive's rollout. Initially loyal, she was offered limited immunity in exchange for full cooperation, and she took it. Before a closed-door grand jury, Jennings testified that Stephen Miller had ordered staff to find legal shortcuts and bury dissenting memos that questioned the directive's legality. But it didn't stop there. Jennings revealed that Trump was personally briefed on the risks, not once, but twice. According to her sworn statement, the president waved off objections with a chilling reply, "We'll worry about the courts after we make the arrests." The leak of that quote to the press sent shockwaves across the country. Cable news ran emergency segments. Legal analysts called it a smoking gun moment. Protesters gathered in D.C., while conservative media scrambled to discredit Jennings, calling her bitter and disloyal. But the evidence kept coming. Judge Mercer approved the release of more internal memos as part of the civil proceedings still underway. Among them was a handwritten note, initialed by Miller, reading, "Remove legal language. Too soft. Directive must be enforceable with no judicial oversight." Even the most conservative legal voices began to acknowledge the obvious: the case wasn't just about overreach anymore. It was about intent. Miller, meanwhile, had grown paranoid and isolated. Associates noted he'd stopped answering calls, rarely left home, and was in constant consultation with criminal counsel. A former friend told Politico, "Stephen always thought he was the smartest in the room. But now he's realizing the room has turned into a courtroom, and he's cornered." Trump's situation wasn't much better. 2 of his former Homeland Security chiefs were subpoenaed, and both indicated willingness to cooperate under oath. Behind the scenes, whispers of a potential indictment spread. In a dramatic move, the special counsel sent formal notices to both Trump and Miller, informing them they were now subjects of a criminal investigation. The countdown had begun. As the grand jury deliberations entered their final stages, the nation stood at the edge of a legal and political cliff. Would the hammer fall? Would the justice system do what had never been done before? At 7:42 a.m. on a rainy Monday morning, it became official. The Department of Justice released a brief but historic statement. Former President Donald J. Trump and former White House advisor Stephen Miller have been indicted by a federal grand jury on multiple felony counts, including conspiracy to violate civil rights and obstruction of justice. The legal bombshell Judge Mercer had predicted had just detonated. The charges were sweeping, conspiracy to deprive constitutional rights, 18 U.S.C. Section 241, obstruction of official proceedings, 18 U.S.C. Section 1512, misuse of government authority, willful suppression of legal oversight. Each carried severe penalties, including potential prison time. The special counsel, Nathan Hale, stood before the press hours later. This investigation has been guided by facts, not politics. The indictment reflects overwhelming documentary evidence, sworn testimony, and intent to undermine constitutional protections for political gain. This is not about immigration. It is about accountability. The reaction was instant and global. News tickers in London, Paris, and Tokyo flashed with the headlines. World leaders issued carefully worded statements. Markets dipped temporarily, uncertain of what such a legal crisis might mean for U.S. stability. Meanwhile, in front of the courthouse, the scene resembled a political earthquake. Crowds gathered, some in support, others in protest. Trump's loyal base waved flags and chanted, "Witch hunt," while civil rights advocates cheered what they called a victory for the rule of law. Stephen Miller surrendered first. Escorted by federal marshals, he appeared gaunt and silent, refusing to answer shouted questions. Trump arrived later, defiantly walking past cameras with his fist raised. But inside the courtroom, he said little. Judge Mercer did not oversee the arraignment, but her name was on everyone's lips. It was her insistence on transparency and accountability that led here. Legal commentators began referring to her rulings as the Mercer precedent. Both Trump and Miller pleaded not guilty. Bail was granted under strict conditions, travel restrictions, weekly check-ins, and full disclosure of communications. Trump was barred from using his Truth Social account to discuss the case, a gag order that set off a firestorm online. Inside Trump's camp, chaos reigned. Several advisors resigned. Fundraising emails went out within minutes, begging supporters to help fight the deep state attack. But none of it changed the fact, for the first time in American history, a former president was facing federal charges for using executive power to suppress constitutional rights. And the trial was set to begin in less than 90 days. It was standing room only inside the U.S. District Court when the trial of United States versus Donald J. Trump and Stephen Miller officially began. Dubbed the trial of the century by nearly every major outlet, the case had captivated the world, not just because of who was on trial, but because of what was on trial, the integrity of executive power in a constitutional democracy. The courtroom buzzed with energy as the jury, 10 women and 2 men, filed into the box. Judge Eleanor Mercer, who had been granted the rare privilege of overseeing the criminal trial due to her foundational role in the case, presided with the same measured calm that had defined her rise to national recognition. "Let us begin," she said simply. The prosecution opened strong. Special counsel Nathan Hale took center stage and, with surgical precision, laid out the prosecution's core argument: this case is about intent. About knowingly stripping protections from the most vulnerable for political points. About ignoring the law, silencing internal warnings, and drafting policies not to defend the Constitution, but to bypass it. He referenced email chains, handwritten notes, internal memos, all pointing to a deliberate, coordinated effort to suppress judicial review and target immigrant populations with maximum force and minimum legal oversight. Then he played a never-before-heard audio recording from a White House policy meeting. In the clip, Stephen Miller could be heard saying, "The Constitution is not a suicide pact. If we need to skip a few lines of red tape to do what's necessary, so be it." The courtroom froze. When Hale pressed play again, Trump's voice followed, "We do it now. The courts can catch up. If they don't like it, they can impeach me again." The defense tried to paint the actions as chaotic policymaking during an unprecedented crisis, but the emails, the audio, the witnesses were devastating. Former aides flipped. One DHS official took the stand and confirmed that the directive was rushed through after legal review was intentionally cut out. "We were told not to ask questions. Just follow Miller's edits." "Did those edits include deleting legal warnings?" Hale asked. "Yes. Explicitly. Meanwhile, outside the courthouse, barricades strained to contain massive crowds. Protesters demanded justice, while loyal Trump supporters rallied under "Save America" banners. Inside, the defense team tried to regain control. They called Trump's former counsel to testify. But he only made it worse, confirming that both Trump and Miller were warned repeatedly that their actions risked serious constitutional violations. The trial was scheduled to run for several more weeks, but even seasoned analysts admitted, the prosecution had landed blow after blow. And Judge Mercer, firm and fair, allowed every piece of relevant evidence to be shown. As the trial reached its midpoint, one question hovered over the nation: would a jury of 12 Americans convict a former president, and his closest advisor, of conspiring to break the Constitution? The closing arguments were delivered on a Friday morning so tense it felt like the country itself was holding its breath. Prosecutor Nathan Hale rose one final time before the jury. This case is not about politics. It's not about popularity. It's about the law. And no one, is above it. Not a staffer, not an advisor, and not even a former president. When power is used to target, silence, and circumvent justice, we call that what it is: criminal. He turned to the jury. You've seen the documents. You've heard the recordings. You know what they did, and why. The defense followed with a familiar refrain, painting Trump and Miller as protectors of national interest under impossible circumstances. But it was clear, even to observers in the gallery, that the tide had turned. After 6 weeks of testimony, 37 witnesses, and over 700 exhibits of evidence, the jury was sent to deliberate. They returned in less than 6 hours. The courtroom filled to capacity as Judge Eleanor Mercer took her seat. Trump sat still, arms folded. Miller looked pale, staring straight ahead. "Madam Foreperson," Mercer said, "has the jury reached a verdict?" "We have, Your Honor." There was a pause. Then, on the count of conspiracy to deprive rights, we find the defendant Stephen Miller guilty. On the count of obstruction of justice, we find the defendant Stephen Miller guilty. Miller slumped forward, closing his eyes. Then came the moment that would be etched into history books. On the count of conspiracy to deprive rights, we find the defendant Donald J. Trump guilty. On the count of obstruction of justice, we find the defendant Donald J. Trump guilty. The courtroom erupted, gasps, shouts, reporters sprinting to their phones. Trump sat frozen. No fist raised this time. Just silence. Judge Mercer called for order and spoke clearly and firmly. Let the record reflect that both defendants have been found guilty on all counts. Sentencing will be scheduled within 30 days. Until then, both are ordered to remain within federal jurisdiction under supervised release. Outside, the news spread like wildfire: Trump and Miller convicted, first former president in history guilty of federal crimes. Protests flared. Celebrations erupted. Politicians across both aisles released statements. Some called it justice. Others called it a dark day. But no one could deny the gravity. Judge Mercer returned to her chambers without a word to the press. But a note later posted to the court's public docket simply read, "The Constitution endures not because of who leads, but because of what we uphold." This court has upheld the law. Let history do the rest. And with that, a chapter in American history closed, one where accountability finally met power in a courtroom that refused to bend.